This module explores how agency relationships are created, maintained, and limited under Arizona real estate law. It reinforces the foundational principle that agency arises from trust, consent, and disclosure, not from payment or assumption. Understanding how agency forms and how it must be disclosed is crucial for maintaining compliance, protecting clients, and avoiding unintentional liability. An agency relationship in Arizona can be either expressed or implied. Expressed agency is deliberately created through a written agreement, such as a listing contract or a buyer-broker agreement, where both parties acknowledge the relationship. This type of agency ensures clear boundaries and documentation of fiduciary duties. In contrast, implied agency is created by the actions or conduct of a licensee that cause a consumer to reasonably believe that the agent is acting on their behalf, even if no written agreement exists. This type of relationship is risky because it can lead to conflicts of interest, confusion, and disciplinary action. The importance of early disclosure cannot be overstated. According to Commissioner's Rule R4-28-1101F, licensees must disclose in writing whom they represent at the first substantive contact with any party to a transaction. This prevents the creation of implied agency and ensures transparency in all interactions. Tools such as the real estate agency, disclosure, and election READE form help agents make this disclosure clear and documented. Courts, including in Barnes v. Lopez, 1985, have emphasized that agency can be created through conduct and reliance, making early written disclosure the agent's strongest protection. A major concept clarified in this module is the distinction between representation and compensation. Representation defines who the agent owes fiduciary duties to: loyalty, confidentiality, disclosure, obedience, accounting, and reasonable skill and care, while compensation simply refers to who pays the agent. A licensee can be compensated by one party but represent another, as long as all parties are informed in writing, such as the seller paying compensation to the buyer's agent that is not representing the seller, only the buyer. This principle is supported by ARS Section 32-2155A and ARS Section 32-2153A, which require that compensation flow only through the employing broker and that all payment arrangements be disclosed to the client. The Arizona Court of Appeals in Lombardo v. Albu, 1996, reaffirmed that the mere payment of commission does not establish agency. Finally, the module addressed the requirements and limitations of fiduciary duties when representing clients. Fiduciary duties: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable skill and care are the legal and ethical foundation of real estate practice. However, these duties are not absolute. Licensees cannot obey unlawful instructions, conceal material defects, or provide legal advice outside their scope of expertise. These limitations are defined in ARS Section 32-2153A3 and R4-2-8-1101A, ensuring that fiduciary duties are performed ethically and within the law, such as Hill v. Jones, 1986, demonstrates the requirement for disclosure of material defects, underscoring that withholding vital information violates fiduciary responsibility. In limited or dual representation, fiduciary duties are modified by consent. Agents must act impartially and avoid favoring one client over another. In compliance with R4-28-1101F, brokers are required to ensure that these disclosures are properly executed under R4-28-1103A as part of their supervisory duties. In summary, the creation of agency in Arizona rests upon written consent, early disclosure, and strict adherence to fiduciary duties. Representation defines who the licensee serves, while compensation defines who pays. But these are never the same by default. By understanding and respecting the boundaries of fiduciary duties, licensees protect their clients, their brokerage, and their professional integrity. Key takeaways for retention: agency can be expressed, written, or implied, created by conduct. Always disclose representation in writing at the first substantive contact to avoid implied agency. R4 28 701. Representation does not equal compensation. Fiduciary duties belong to the client, not the payer. All compensation must go through the employing broker per ARS Section 32-2155A. Fiduciary duties include obedience, loyalty, disclosure, confidentiality, accounting, and reasonable skill and care. But they have legal limits. Courts in Barnes v. Lopez, Lombardo v. Albu, and Hill v. Jones define and reinforce the boundaries of agency, disclosure, and fiduciary obligations. Ethical compliance, documentation, and communication are the strongest safeguards against liability in agency relationships.